Okay, good morning, ladies and gentlemen. Morning. I am Richard Wee from Richard Wee Chambers. In collaboration with BAC College, we are a law firm in Petaling Jaya. And of course, BAC College, we are collaborating with the law school. Today, this morning, I'm going to record this webinar in a short while, but this morning we have two officers from the Malaysian Anti-Corruption Commission, and they are Mr Thilaq and Mr Jayantha Kumar. How Jayantha? Hi Thilaq, how are you? Morning.
Hi, good morning.
Morning.
Yep.
Morning, V.
Quite a gloomy weather, huh?
Happy Environment Day.
Yeah, today. So, okay, if you are ready, I'm going to click record on Zoom. Then we can start chatting lah. Nice cover page lah, Jayantha. This is your standard one, is it, that you prepare?
Yeah.
Cantik.
Actually, I got a, we have another serious title there, but I don't want to scare anyone.
Slowly. Mamanle, yeah.
1 month late, yeah.
Okay, I'm going to record the Zoom's one in 5 seconds. 5, 4, 3, 2, 1. Okay, now it's recorded. Once again, I repeat, good morning, ladies and gentlemen. So far, we have got 13 registered participants. Thank you very much for registering to the participants. We have people in the Facebook watching in. In fact, from our participants, I see other than Raymond Patrick, we see Dr. Loy. Thank you, Dr. Loy, for signing in 2 weeks ago. RWC was quite pleased to have the opportunity to host Dr. Loy to our webinar where he introduced 17A and ABMS, Anti-Bribery Management System, vis-a-vis ISO 37001. Unfortunately, that talk for some reason could not connect to Facebook, so we lost the opportunity to broadcast on Facebook. But today we managed to go into Facebook. So today, ladies and gentlemen, is very significant. With the coming into force of 17A MACC, I think it is never better time now. Never better time for this now to have Mr. Jayantha and Mr. Thilaq, both from MACC, who are part of the Community Education Division of MACC, to share some thoughts here. And just to share a small insight to the participants, there are now 19 of them in this group, that Mr. Jayantha and I are actually old schoolmates. We were both from Sekolah Menengah Sultan Abdul Samad, a very good school in Petaling Jaya, where we were classmates in Form 6. Yeah. When I left Ipoh from St. Michael's, I landed in PJ. I joined Samad, and among the first friends I got to know was Mr. Jayantha Kumar. Yeah. So Jayantha, hi. So Jayantha, maybe well, it's only 10:01, so maybe could I trouble Mr. Thilaq and you, just a quick introduction, who you are, what you're doing in MACC, and more interestingly, I think many people would like to also understand, before we go 17A, what is this Community Education Division about? And because, as you know, Jayantha, both of you and me, our idea is to promote your division so that more people will engage your division to give a talk, right? Not just at Richard Wee Chambers, So all yours, Jayantha.
Yeah, hi, good morning, listeners, from the BAC webinar. Nice to have all of you all on board, and I think this is the first colleges, first colleges to actually organize such such a session, specifically on 17A. Congratulations to BAC and Richard for taking this initiative together with BAC, because we believe that it will be something useful for students of law as well as for the general public, because now now 17A is really going to be a monkey on your back. It's going to be burning behind you. So if you're not ready, if you're not ready with the cooling off products, cooling off initiatives, then it's always going to be something that is going to be burning behind you, right? So I'm sure nobody wants all that. Well, just a brief introduction. My name is Jayantha Kumar and I'm from the Community Education Division of the MECC, and currently I'm the head of community relations. So, and also a spokesperson, together with my colleague here, Thilaq, spokespersons for the 17A topic. So, as such, well, like you said, what do we do? What does community education do in MECC? Basically, we are smiling boys. We are the fun-loving guys. We go around, we joke. We have a good time sharing sessions. We don't, we are the nice fellas whom you should listen to, because we go out and deliver talks. We organize public programs, seminars, trainings of some sorts, campaigns, promotional kind of activities, basically to increase awareness on the information and education on anti-corruption. So anything which is related to the awareness of anti-corruption comes to this particular division, and we are always there 24/7. Any organization, any group of people, you're most free to engage the MECC in any talk, anytime, 24/7. Yeah, and 24/7 means we really mean 24/7, because by law that's how we function. It's by law. It's a legal requirement that we are 24/7. So it's not just based on policy or things like that. So that's how serious we are, and that's how responsive we are. And it covers from any topic. Of course, now the hot topic is 17A. So that's what we basically do. And there are loads of programs that we organize, and also initiatives that we introduce and promote to various communities, right from schools to government organization, private organizations, colleges. For example, we have some sort of club fraternities, so to say, in institutes of higher learning. It goes by the name of AMAR, which stands for Angkatan Mahasiswa Anti Raswa. This was previously known as SPR, which is Secretariat Pencegahan Raswa, and this is something, an initiative which transpired in the wake of the time of the National Key Results Area, or NKRA, or Government Transformation Program, GTP 1.0 and GTP 2.0, whereby the government then, under Tun Abdullah Ahmad Badawi, had instructed that due to some very glaring and very concerning statistics of some survey, which showed that almost about 60% of students were willing to engage in corruption if given the opportunity, or if some opportunity prevails that would result in them obtaining some benefits for their own purposes. So that was a bit of a scary finding, and that's how this particular initiative
came about.
Was initiated, and it has been in town. It's actually very much alive in every public university, and there are few private universities that have also taken on this initiative. So maybe the next step, BAC could be the next private university that may want to set up this AMAR initiative, which involves basically the students, and it's I think to make it very simple, it's similar to a club, a club in a school, or a club in a university. So you can call it an anti-corruption club or things like that, but it comes under the name of AMAR.
It's very, very good initiative. Well done. Nice to hear the every time we hear a short history of something significant like MECC's department, it's very nice. Then you understand and realize what happened. Yeah. So okay, welcome aboard. Go on.
And I think what you call Thilaq, it's time for you to introduce Thilaq here. He's a man of many years of experience in operations. I think I won't say much.
Sorry, Thilaq, the sound system seems to go up and down once in a while from your side. It could be the microphone. So, but never mind. So far, we were able to capture the essence of what you speak. How are you, Thilaq? Morning. All yours, Thilaq. Morning.
Morning. Fine. Okay, I introduce myself. My name is Thilaq Munusami. I am also from the Community Education Division. I am in the private sector. So my job is more on catering companies, private companies, GLCs, on educating them, and specifically on the Section 17A, the new one. I've been working in MACC 14 years, but this is my first year in the Community Education Department. Previously, I was in operational for the past 13 years. So I think that's about it, about me.
Hey, thank you, Thilaq. So it looks like you're the man to go. I better get your business card afterwards. Yeah, but
I don't have a business card.
But actually, at this stage, I think both Jayantha and you are spot on that we need to have talks about this, and to be frank, Jayantha, while everybody is excited over 17A, people like us, we've been around for a long time. It's not just 17A, there's Section 20, 23, there's Section 16, all these other provisions. So we may want to do a very quick introduction about the other bribery offenses later. So thank you. Very nice introduction, but we'll come back to the two of you. So ladies and gentlemen, again, I am Richard Wee from Richard Wee Chambers, for those who just logged on. We have 28 people here on the webinar, and not bad for an early morning webinar with a gloomy weather. Everyone is sleeping. I'm not surprised here. But we also got quite a number of people on Facebook logged on. Yes, Jayantha? Okay, your line, okay, yeah, but I think I know what you said, yeah. So, if you have any questions here for those people on the Zoom webinar, you can see below your screen there's a chat format, chat icon. You can click on the chat icon, and then you can provide offer some questions. Of course, Thilaq, Jayantha, and I will attempt to address these questions as we go along. This is a 1 hour webinar, and I do hope we can finish within by 11 or 11:15. I'm sure everybody have their own plans thereafter. So then, at the same time, those viewers who are watching on Facebook, I will try to go to Facebook later to check your Q&A, but I doubt we have sufficient time there. But at the end of the session, you may hear the Q&A from the participants and the answers from the two speakers. Now, Section 17A, let's jump into the session. It's already 10 o'clock, 10 a.m. So Jayantha, Thilaq, we all know on 1st of June, the government of Malaysia finally announced about, I think 2 weeks ago, that Section 17A will come into force. And this provision was first introduced in Parliament in 2018, just before the 2018 elections. And 17A is one of the few amendments to the MACC Act. It's not the only amendment, right, Jayantha, right? Yeah. Then after that amendment, 2018 December, the Ministers and Prime Minister's Department in charge of law issued a guideline vis-a-vis for Section 17A sub 5 adequate procedure, which we'll be discussing afterwards. And then, of course, recently we have the announcement by the government. In between there, I think the former Prime Minister before Tan Sri Muhyiddin, Tun Mahathir, he actually came up with a anti-corruption plan. Jayantha, is a major plan, and that may be something we if we have time, we may have a chat about that. So without further ado, ladies and gentlemen, I hope Jayantha's microphone is clearer because it's been going in and out. So Jayantha, to kickstart our discussion, let me pose some question with you, and then we'll try to make this interactive and a dialogue as compared to a lecture. So, Thilaq, Jayantha, 17A has about six major provisions, right? Let's give a quick background and history about 17A. Can you share with us, Jayantha, Thilaq, maybe some background history, how 17A came about? All yours, Jayantha.
Okay.
So your microphone, do you have this? Because I think maybe your
okay.
Sorry,
Sure, we'll just get it.
Because it goes in and out, and then sometimes you talk midway through, it just drops. So sorry, Jayantha, sorry.
No worries.
Yeah, while waiting for Thilaq, maybe you can give an attempt. Can you attempt to try and answer these maybe a background history of 17A?
Okay.
Okay, the microphone is here. Okay. So maybe later you and Thilaq have to share it.
Okay, yeah. Is it clear?
Okay, very good.
Loud and clear, huh?
Loud and clear. I repeat the question. As we know, 17A didn't pop up just like that. There was a lot of background, and you and I went back a long way, 4 or 5 years ago, 6 years ago. We had discussions about this. Maybe I repeat. Would you like to share some history and background towards the formation, which end up towards the formation of 17A in 2018? All yours, Jayantha.
Okay, basically, 17A is not something new. I think it began because, number one, you see, when we look at history and what has happened, we have seen that corporate liability, things like corporate liability, accountability, and many things. For example, like when you talk about ethics, when you talk about things like governance and so on and so forth. These were something of alien terms, until a big organization called Enron, sort of hit the world, and the scandal with Enron actually led to an act to actually address ethics and integrity in the business sector, and especially corporate world. And that's how, in 2002, the SOX Act, or basically the Sarbanes-Oxley Act, had come about. And that's how it gave rise to corporate governance and so on and so forth. That's why today, corporate governance is like a buzzword. It's like a core term, core vocabulary in corporate reporting and so on and so forth. So that is one. So everybody thought that everything is going to be fine, everything is going to okay. SOX is going to take care of things until the next scam comes in, which is Satyam. Satyam, another big company. Again, the people who were implicated were their top officials. Basically the CEO, the people who are running the organization, and so on and so forth, right? And I'm sure if you Google, you'll know what's Satyam all about. False reporting of the accounts, and so on and so forth. And then, of course, then comes, when we think that everything is okay, or maybe people would have learned their lessons, but it still goes on. Then we had the scenario, we had a case with Siemens, another big, huge company, reputable company. And I must give you all an indication that, names like Enron, Satyam, Siemens, lately it has been Boeing, and so on and so forth, are big companies. They are big brands, they are major brands, and it's surprising that such big, huge brands actually, we end up finding out that they are in such scandals. So if the big boys do it, what more, possibly the small boys, right? So it could stretch out, it could pan out to many other small organizations as well. Now, Siemens, of course, they went through their thing, and Siemens was direct case of bribery, whereby the officials, basically the managerial staff and everybody else, mostly Siemens, were engaged in bribing officials, in organizations, whether it's the private sector or the public sector, in obtaining businesses. And that was the buzzword in Siemens. It was some sort of culture which actually, was what became a widespread thing. Maybe that seems to be a buzzword now with what do you call with our COVID and so on and so forth. So that was then, and that's how actually slowly, then we have our Barang Buatan Malaysia, the issue with YMDB, so many things.
Nice.
It has become a main concern in Malaysia. So forget Enron, forget Satyam, forget Siemens, forget about everybody else in the world. We have something in our backyard which we need to clean up. And people talk about corruption, corporations, and so much. So let's address the elephant in the room, and that's what we have in Malaysia. We are not short of our own episodes as well. So as such, this whole thing has been going on, and there's a need as such for corporate liability to take place. As we has already mentioned, right? It was passed in April 2018, but actually the entire idea was already sort of going back and forth from various agencies. Since 2012, 2011. So it's not something new, because one of the requirements is basically, I would say, it's under the UNCAC, fight under the United Nations Convention against Corruption. And as such, Article 26 under UNCAC provides for liability for legal persons, especially in the corporate sector. And this is basically to say, in a nutshell, is to combat corruption in the private sector. So it is not only something that Malaysia wanted to do, but there is also an international obligation to fulfill under UNCAC. And being notified of being a member of the UNCAC community, then as such, that's the reason, that was one of the strong reasons why this whole corporate liability provision was sort of introduced. And that took some time, but thank God in 2018, it had come about. And today, we are 5 days old, 5 days old of its enforcement. So I hope nobody is willing to test the law. Well, if anybody wants to be, what do you call, a guinea pig,
yeah,
if you want to, record yourself in the Malaysian Book of Records, we can try to enlist you as being the first case. So
you may want to.
Let's hope not.
Let's hope not. You're right. Yeah.
Let's hope.
But nice starting. Before we go deep into 17A, Jaya. So this basically with the background of the past cases and also the rules, international rules or international laws of particularly from the United Nations. Did we also, from your understanding and your knowledge, did Malaysia also refer to other countries like maybe in America and England who also have anti-corruption corporate laws? Did we do that?
Oh yes, in fact, we are, the forefathers of this, so to say, or the godfathers of corporate liability is basically the US FCPA, which was up since 1977, and also the UK had adopted the majority of the US FCPA, and refined it, made it even more robust and stronger. And I think today's UK Bribery Act in UK is possibly the most lethal, bribery act, especially when it comes to corporate liability. Because when we look at the penalties under these two big robust acts, you have not only the traditional fines and imprisonment, but you have things like, industry sanctions, public procurement ban, parallel prosecution, which, parallel prosecution is deadly. It's a double whammy, right? You get it in both jurisdictions, and that's evident in UK Bribery Act. Right? While most countries we go on a lat talilat tamplum, either you do it or I do it. But nevertheless, when it comes to UK, it's you do it and I will do it.
Yeah.
So if you were to, please don't mess around with the UK Bribery Act. That's the first caution. Of course, they have delisting, debarment, and corporate monitoring and all that. Malaysia, corporate Malaysia is very, very fortunate. As later, when my colleague Thilaq will go through the details of the 17A and the penalties, you would see that most of these penalties do not appear in Section 17A. So corporate Malaysia is quite fortunate. But needless to say that there would definitely be revisions to it, improvements to it, and I'm sure we would recommend some of these, as well as we would also, the government would also look into some of these penalties to see to ensure that we are serious in combating corruption in the corporate sector. I think that's basically what the background on corporate liability, how it came about. Where did we fall back on? Where did we refer? It just didn't come out from the rabbit's hat or our Malaysian Houdini or things like that. But it was because there were a lot of background.
What I'm going to say next, Jayantha, we're not discussing it today, but it is interesting to observe that in UK, and correct me if I'm wrong, there are case laws where a company can actually be charged if they fail to have sufficient adequate procedure in their organization. So here, while adequate procedure is a defense under 17A4, if a company offer showing that for those who hearing this for the first time and don't understand what is 17A, if a company is being charged, a director is being charged, but the director can show that the company has done adequate measures, as you can see on the screen, that means you put into force to try and prevent bribery and corruption in the company, then you may have a defense in court under Malaysian law. But in England, not only it become a defense, but if you don't have adequate procedure, that itself is a charge, isn't it? That's in England. So the law in England has evolved quite at once. The anti-corruption for private sector. We are at the early stages of our law. So we will evolve. I'm sure we will evolve. So now, very good start, Jayantha, Thilaq. Unfortunately, Jayantha, just to let you know, once in a while your side, the signal drop a little bit. So don't be surprised if, unfortunately, I may have asked to ask you to repeat some areas.
No problem.
But I will prompt you. So back to this. Now let's go into 17A. Maybe as an introduction, both Thilaq and you can offer a very quick summary. So if you meet someone on the street for the first time and the guy shake hands with you and say, "Bro, what is 17A?" And in 1 minute. So maybe you can start off with that first. Give us a quick intro of 1 minute 17A before we go into 17A1 and 6 and 4. All yours, bro.
Okay, basically 17A, as we mentioned, is for corporates to actually have anti-corruption measures to prevent corruption. So basically, in a nutshell, under 17A, if a person, an employee, is caught to be involved in activities of corruption, which relates to the affairs of the organization, and should the company not have any anti-corruption measures, then the organization and the controllers of the organization can also be equally sort of penalized and implicated in the court of law under the MACC Act. So in a nutshell now, because of the act of one person, and should you not have any anti-corruption measures, then the law will deem that the organization is condoning to acts of corruption. And as such, it is the burden of proof is now on the organization to prove that it has, as its defense, it has adequate measures to prevent corruption. Failure to do so, the organization can be implicated, and together with the organization, of course, the organization is not a living entity, so there must be some people who are controlling this organization. As such, the law looks at the controllers. So controllers, basically, later, Thilaq will mention, they are the ones who could also be implicated as well. Now, the objective is very simple. Is basically, as you see on your screen, to establish a corruption-free and integrity-based business environment. That's what we want. To have anti-corruption framework in the organization, which is the main thing. This is a preventive law, I must tell you. And that's why we are going around giving talks, giving briefings, educating organizations, giving them advice, explaining what is this whole thing about, what possibly they could do, and how they should go about doing it, things like that, so that they do not end up in the courts, right? So it becomes basically, if something were to happen, then they can say that it is basically the act of an individual and not something that the organization is sort of encouraging or allowing to happen. And also on a holistic nature, it is to promote good governance and legal compliance. You must see, I think about a month ago, there was an article in The Edge, and it highlighted that only actually 50% of corporate Malaysia has put in efforts to have anti-corruption framework. Now, that is something very, very alarming, looking by the fact that the law today is fully in effect, and only 50% of organizations are possibly ready for their defense should anything happen. Should one of their employees be caught for acts of corruption. So, which is dangerous. 50% of corporate Malaysia can be liable and dragged to court. And I think if you go by what you said, based on UK Bribery Act, the fact that you do not have anything is already an offense.
Yeah, over there in England, yeah.
Over there in England, right?
But,
okay.
I was about to say, Jay, before we go on, we have 32 people here, and we've got quite a number of people listening to us on Facebook. Thank you very much. For those who are listening into 17A for the first time and still trying to understand, I know some of you here on this group are experts in 17A by now, but there's still many people out there who don't understand. So permit me to repeat something basic and elementary. For 17A to come in, let's first talk about the people who can get, let's work backwards. Who are the people who can get charged under 17A? There will be examples, managers, company auditors, financial officers, president of company. There are still companies who call themselves president of companies, secretary of companies, company accountants, partners of partnership, or LLP, CFOs, CEOs, and of course, director of companies. Now, for these people to be able to be charged, I hope they will never be charged, but if they are charged, it's because of 17A1. Now, what is in 17A1? Long story short, if I am a director of a company and my subordinate had a corrupt practice which falls within 17A1, that means not you, somebody below you is doing a corrupt practice, you may be liable in court. Correct? Am I correct, Jayantha? Is my understanding? I'm trying to make it very simple. Thilaq, Ken?
Yeah, I can hear you. But I think you've done my job. I already explained the section to them.
Sorry.
No, it's okay. It's okay.
Yeah. All yours, Thilaq, sir.
Okay.
Sorry, as a lawyer, we start thinking about law. Maybe Thilaq on this part, because I think people want to know who can be liable and why are they liable. All yours, Thilaq.
Okay. No problem. Okay. First of all, good morning, everybody. Okay. Straight to the point, who is liable? Okay. The person who is involved directly in the issue, meaning to say there is all liable persons are the directors and the controllers, depending on their linkage to the offender. Meaning to say, if it is a unit, just say it's a sales unit, and there is a manager on top, and after that there is the direct link to, because a board of directors will be like 10 people, 7 people, and the board of directors will be in charge of the sales unit. So he is the one who is directly linked, and he is the one
directly linked. Okay.
Mainly he is the one who's responsible. That is an example of who is the liable person. Not mean to say that 10 board of directors, 10 people, all of them are going to be charged. No.
Yeah.
The liable person is depending on the offender and which department or who is his direct boss. That is the main thing in this offense. But to make it very clear, I think we still have to wait for somebody to be the first case to be charged, the president case.
Yeah.
But this is around something. This is an example of the who is liable, because in the act it says the board of directors, but it is not clear because it doesn't specify. This is the specification, depending on the unit of the offender, who is his direct boss. Okay. Then I think we start back from the. Hold on. No. Okay. Section 17A. A commercial organization committing an offense in associate with the commercial organization corruptly agree to give promise to offer for gratification for the benefit of the person. Okay. This is actually very simple. Anything that done by an employee or somebody connected to the company in benefit for the company, not for that person. The benefit must be for the company. Some kind of projects, tenders, any government projects, all that which benefits the company, then that comes under section 17A, because I think everybody should know, when it is concerning the company and the benefit is for the company, most probably the corrupt money or the corrupt services or any other gratification was from the company. Because there's I don't think I'm working 13-14 years. I've never seen some company manager come out with his pocket money. Boss, any semi duit lo ambil and then give me a tender from my company. No way lah. I don't think you can find that is considered not employee of the year, the employee of the century lah. Then so it's very clear that any corrupt practice done by an employee for the benefit of the company, most probably the money came from the company. That is why the section 17A is very relevant, because now company has to be responsible. They cannot say, I don't know, my manager did it. No way. Because surely the money or the order from the director, hey, you take care of this officer.
Yeah. Take care. We all know that phrase. Take
because
care.
I don't think any manager, any employee working in any company is so like loyal. This is not like the old centuries. You're so loyal to your king, you'll give your life for the king. I don't think so. No lah. So nobody's going to come up with the pocket money. So that's sure the money came from the company. So that is why 17A is very relevant. The company should be responsible.
Good. Very good.
You have to educate your staff, because end of the day, your staff is not that stupid to go and I pay my pocket money first, then I claim from my boss. I don't think so. So when your staff is doing something for the benefit of your company, then it is on your order or on your advice, or previously you would have been a director or a manager, you would have told him anything concerning this, please handle it with discretion thing. So that is why now the company should be responsible and they should educate their staff not to do this anymore. That is the main reason for this section 17.
Yeah, it's like what Jayantha said earlier, is a preventive. Well said. Thank you. You really made it very clear, Thilaq. But of course, as a lawyer, I can already see the kind of issues. Whether, for example, whether it is a direct benefit or indirect benefit to the company.
Yes.
And you said it can be employee or connected person. So it could
connected
be
person.
Yeah, even could be people like lawyers, or auditors. So we work for the law firm work for the the company. So everyone has to be alert and has to be responsible and accountable for this. Basically, yeah.
Okay.
So-
For the section 17A,
Mm.
it is actually not that shady or anything. It's very clear. The moment an offense happens and a person is arrested by my department, saying, just say a manager is gave money to another company's manager or a government servant or anybody, and then the offense is established, meaning to say there was an offense that has happened, then it automatically complies to 17A.
Yeah.
Automatically, the company is reliable
Liable.
already.
Yeah.
There is no more saying we have to check whether they did their measures. Yes, that is the later part. But the moment your staff commits an offense, giving money or giving something, giving services, something to try to obtain. It doesn't mean you have to obtain. You know, a lot of people maybe make mistake in this, thinking that, oh no, I tried to talk to him, I didn't get the tender yet.
Mm.
Or I didn't get the project yet. This hasn't happened. No, it doesn't mean that. The moment you commit to do something, it's as what you know lah. Lawyers should know lah. It's nothing to do with actors ria. It's mens ria. The moment you attempt, it's done lah. So I'm sorry, you cannot talk there. I didn't get any project. I didn't get any profit or anything. I just tried to get it. Sorry to say, when you try, it's gone lah. There's nothing doing because a lot of people think when you offense has not been committed yet, they have a chance. No.
Yeah.
The moment your manager, anybody, your staff tries to bribe somebody, and then automatically he gets charged, your company gets charged, everybody lah.
Yeah.
So
Interesting.
that is why you have to educate your staff.
Yeah.
And this thing, sometimes some people try to play smart lah. Maybe I do something for my boss so that I get promoted. Sorry to say, he won't get promoted. Most probably you will get demoted lah.
So basically, thank you, Tila. I'll come back to you. Don't go away yet.
Yeah.
Basically, in short, we went backwards. I wanted to make it easier to understand. You see, when we discuss with the people, Tila, to start off 71 and then reach 17.6, right? Some of the people trying to figure out, why am I liable? But the moment you tell them these are the people who may be liable, you get their attention straight away. Then once you get the attention, then they ask you, I'm liable. Then you work backwards. So then we noticed that is a much easier way to explain to our clients.
Because if you're a lawyer, I think you can understand the sections lah. But if you're a layman, this is a better way to explain to them.
Yeah, to make it understand. Yeah. So now that we know that like as you listed people as a partner, even partners can kena, LLP partners, directors, blah blah, may be liable if they're not careful. Now let's now go towards the kind of defenses that the person who may be charged may defend himself.
Okay. For the defense of the company, okay, Malaysian government has come out with a guideline. I think this came out in 2019, if I'm not mistaken. It is called the principle of trust, which was by the Department of the Prime Minister's Office.
Yeah, 2019. Sorry, earlier on I said 2018. My bad. It's 2019.
No, 2019, because this 17A Act was passed in Parliament in 2018. And this is just for information lah. Among a lot of people who are now cursing our former Prime Minister, Najib Tun Razak, this section was passed under him,
Yeah,
before the election. So
I know.
Out of all the blunders he did, this was one good thing lah.
Yeah.
So okay, this section was passed under him like his time. So it was a good thing lah. But this etiquette measures comes under reign of our former Prime Minister Tun Mahathir. This was done by them. So let me pass it to Tuan Jayantha to explain more.
Thank you, Tila. Hey Jayantha, welcome back. So let's now talk about 17A form. Let me tell you, Jayantha, my process. Once we finish all this, I do want to go back for quick one, 17A, to show our listeners what are the offences under the Bribery Act, under Corruption Act. So so that they will give a full understanding then by then. So, but now, because our semangat already in 17A, I don't want to go to that. Our semangat is here. Let's now talk about 17A sub 4, where the director or the partner, etc., can take out the shield, like Captain America, the shield. This is the Captain America shield, Captain America shield. 17A4, adequate procedure, all yours. Tell us about the shield.
Okay, so basically to safeguard your organization and for the sort of I would say the parents of the company. You see, when you take an analogy, why the controllers are held responsible? It is similar to the concept of a family. You have the parents, you have the children. Now, in an organization, who are the parents? They are the people right at the top. So the board of directors, the top management, they are the parents of the company because they know the entire affairs of the company. They make decisions for the company and on behalf of the company. They know what is best for the company. It is different from people down at the bottom, whereby they are only specifically responsible for specific areas, areas of the operations of the company. So that is the reason why the law takes it that the associated persons, so to say, and persons who are liable are basically firstly at the core level are the parents, right? Just like in a house, the parent can't just say, I don't know what my children are doing. If they did it, so I don't know. I don't want to know. So are you then fulfilling your duty or your duties as a parent? So likewise in an organization, it is very, very similar. So in order to protect such people and also everybody else down the road who are involved in the as a defense, is that you should have in place adequate procedures. Now, adequate procedures is a term, and it is under the ministerial guideline. And I must forewarn here that this is only a guideline. It is not to say that if I take on whatever that is said in the guideline, it is the gospel truth and so on and so forth. No, it is it's cast in stone. No, it is a guideline. It is just to guide you to say it is based on a principle, and this principle actually is a framework of understanding for which if you then feed products and initiatives into this framework, then you would have something called a framework. Now, this framework, then you could use it as a defense for you to prove to the courts or prove to the authorities that as an organization, you do not condone to corruption. As an organization, you have taken measures and steps to prevent corruption from happening. As an organization, it is your culture, it is your DNA, it is your code of ethics, it is your code of conduct, code of corporate governance, and so on and so forth, that prohibits acts of corruption in any form, in any way, by any person who is involved in the company. So this is going to protect you as the responsible people of the company as well as the organization. Only then when you can prove this defense, then the entire legality or entire case then falls on the individual, whereby then the individual will then be implicated either for section 16 or say section 17 or 18 or 23, whichever one, right, that is applicable under the core offenses, which we'll go about later. Now, these entire etiquette procedures go by the principle of trust. Basically, T stands for top level commitment, R for risk assessment, U for undertaking control measures, S for systematic review, monitoring and enforcement, and finally T for training and communication. Now, when you look at all this, it is not rocket science. It is very simple, it is very basic, it is very elementary, but it is the foundation of any basic understanding. If this foundation is strong, then you have good grounds to defend yourself. Top level commitment. Why do we say top level commitment? Because the associated persons, the core people who could be implicated, should there be an absence of adequate procedures, then it would be at the core level would be the controllers of the organization. So that's the reason why we have the government has started with the principle which states top level commitment. So which means now top level people at the board, people at the top management can say, oh, I was not briefed. Oh, I didn't know, oh, this was happening. Oh, nobody told me anything. Oh, I did not sign. Oh, I'm not sure. You can, like I always tell my audience, they always say, there's a saying, in English, ignorance is bliss. But I would say now, under 78, ignorance is iblis. So if you all know the meaning of iblis in Malay, so it means Satan. So ignorance is not saint, ignorance is Satan. So please do not claim ignorance, because at the top level, because you are paid to be responsible for every single decision that is made in the company. The CEO, the MD, the board of directors, they go through every single level of communication, every single activity. So they cannot claim to say that I don't know. They must know. Now it must be a duty of care. Because I think I think if you can later elaborate on the company law and the requirements of the Bursa and all that under the what you call board of directors, there's something called duty of care. So you must put in place, or you must what you call activate that duty of care to the highest level. It must be a committed level. You should know what your family is doing. As you must know what your children below they are doing, and you must be equally aware. But by this, I'm not telling you that you must sit down in every single meeting and every single meeting and so on and so forth. No. Now, what you should do in your meetings is to put anti-corruption discussion or addressing anti-corruption issues as a core agenda in your meeting. You should be asking questions. You should be now requesting for information. You should be now calling in possibly the head of department, or maybe the general managers or senior management, and to say, okay, we have found out, there's some things going on. Okay, how is this process? Is it done properly? Okay, can you please brief us? So a lot of briefing, you should have more information now, right? Because when signing off, everybody signs off. But how come when explaining, you're unable to explain? Were you blindly signing? And that's the reason why the term used here is commitment. Commitment means not just being present. Commitment here is being involved. So you should be more involved. You should put in more duty of care. Okay. Next, of course, and also top level should give enough encouragement and enough importance for such anti-corruption framework to now be a core element within their organization culture and organization processes. So they should provide a lot of encouragement, basically giving the go-ahead, the motivation, and even looking into resources, human resources, financial resources, to enable the people down there, the managers, the senior managers, the middle management, top management, to be given that motivation, to be given that encouragement, to be given that leverage, to then engage into this very, very important thing about setting up or coming up, building up their anti-corruption framework. So that is the type of this trust principle is looking at. So basically, you're no longer someone that sits down and just listens to something and then just signs documents. No, you should know why you are signing the document. I'm sure you do not want a situation where, oh yeah, I signed, but I didn't know what I signed. We do not want such, instances, because I think Malaysia, over the past few years, we have heard enough of all this sort of nonsense, right? I'm sure you do not want to hear a few more episodes of, oh, I didn't know I was signing that kind of document. Then why were you signing? Were you signing blindly? So where is your duty of care? Especially when you pen down your signature. Okay, secondly, now once this whole organization has got the top level commitment, top level comes and says, yes, we should have this, and this is how we're going to do it. Okay, so what are the requirements? What should we need? So they give their blessings and they give their go ahead. So what then should the next level of the organization conduct is the second principle. risk assessment. So you conduct a risk assessment, and this is similar to any risk assessment that you do. The principles and the workings are the same, but here is very much looking into areas of corruption. So assessing the risk of corruption that could occur or that could take place in a company. So here is where the risk assessment exercise now looks into a review of the various processes, review of policies, review of procedures, and to have a scope into where could there be possibility of corruption happening. So where areas that could possibly, upon assessment, rate as high risk to corruption, then what are the mitigation plans and what are the cause of action and so on and so forth. All right, where is the recovery and how do you address this particular risk? And of course, in risk assessment is looking at the root cause. It's always on a root, it is based on a root cause analysis basis. So you look at the root cause of this entire problem. So you have the issues, but what is the root cause to this particular issue? That's how you then work backwards and to mitigate that particular root cause, and to then develop or come up with or outline the various mitigation plans and course of action to sort of to eliminate this particular risk, right? Now, so once you have done this risk assessment, you would know what to do next. You would have your plan of action. So that's when you look at principle 3, it is quite self-explanatory. It says undertaking control measures. So you then roll out your particular mitigation plan, you put it out there, and you make it happen. You initiate it, and you let the machine run. So while the machine is running, of course, I think I don't have to explain much. What do you do? So
okay.
For example, undertaking control measures, for example, now you would look at things like due diligence. So how proper is our due diligence processes? Are they tight enough to ensure that what do you call this? There are no room for corruption. We have.
Sorry, can you repeat that part? Can you repeat the last one? The line dropped. Yeah.
Due diligence.
Okay. Yes.
Did you get the part on due diligence?
Yeah,
yes.
The part. Can you repeat the part? Sorry, it just dropped. The signal just dropped.
Okay.
Yeah.
So basically, to look at under control, some of the things that you need to look at under control measures are basically like due diligence processes. How tight are they? Are they tight enough so that it does not provide room for corruption to take place? For example, if you take the scenario with Siemens. Now, when Siemens went through their thing, of course, they when they were implicated by the USFCPA, they of course applied for DPA, which is Deferred Prosecution Agreement. And upon agreement, of course, there's certain things that they had to do. The courts then told them, okay, we would agree with the DPA under the following instructions. So one of it was they took a series of major engineering, refurbishment, changeover of everything in Siemens, right? And one of it was a due diligence process which they have in terms of tenders. Now, what they did was, one of the measures that actually they have put in place is they would conduct a due diligence on localities. Basically, if there's a tender being offered, let's say, for example, somewhere in Liberia, so they would study that particular locality where the contract or where the tender or where the project is going to take place. Now, upon that due diligence, upon that survey, if they find out or if they come to know that should they engage or should they win this contract and get into the project, they would possibly be facing a lot of possible corruption and high level of corruption, let's say. Now, if they find out through their due diligence this is going to happen, then their new policy actually advises them to say, back out from the deal, back out from the tender. This is not worth it. Even though you will make millions, but you are going to encounter with a lot of possible corruption. So they would back out. So these are some of the due diligence examples that companies can take. So Siemens have some of these processes. Like I said, in many other companies, they might have various, it depends on the nature of your organization. Now, second one is things like reporting channel. Do you have a whistleblowing platform? Do you have a whistleblowing process? How do you process your whistleblowing? Is it tight enough? I've had companies who say that, Jay, we do whistleblowing in a very independent manner. And I'm like, wow, this is fantastic. So my next question is, how independent are you? Well, we don't handle anything about whistleblowing. We outsource it to a consultant. I said, God, you have done a biggest blunder. Because there's something called first information report. Now, under I think you would, this is something familiar to you.
FIR.
FIR. Yeah. So who is going to be the FIR? Is it you as the company, or is it going to be the consultant? So definitely, by virtue of outsourcing it, it is going to be the consultant. Now, are they ready to face the law? Are they going to work with the law? So it's going to be a different ball game. So, most of the time, these are the things that you need to look into. How do you then work out your whistleblowing process? And in whistleblowing, the most important element is protecting the confidentiality of the individual and the information. For example, though in Malaysia we have a Whistleblower Protection Act, nevertheless, under the MACC Act, also we have our own act that protects the confidentiality of the informer and the information provided. So that's how independently we protect our informers or our whistleblowers. So of course, the Whistleblower Protection Act is a good complement. It is a good support. It is a second layer of protection, and things like that, right? So it is very, very important then for you to know how you're going to how protective, how secure is your whistleblowing process, so that to build confidence or to provide confidence to your whistleblowers to come and report acts of misconduct to you, especially when it comes to corruption and all that. So that is one area. Then other things are like various other policies, gifts policy, sponsorship,
donations,
donations, entertainment. Because you must understand, most people, a lot of many times people get confused between gifts and a gift can also be a bribe. If you satisfy the ingredients of the offense, then a gift can also be a bribe. Right. So you must be very, very careful. You must have certain guidelines on gifts. What is the threshold of gifts? What is the threshold of entertainment? What is the policy on entertainment? Do you simply entertain anybody and everybody, or do you just friends? For example, if you take, there's some companies that have a gifts register, whereby you have to, like in the government sector, there is a gift register, and every government employee who receives a gift, especially on their official assignment or official public engagement, let's say they're given a souvenir or things like that, they must declare to the office, right? They must declare. Of course, the threshold is a value of 500 ringgit. So up to 500 ringgit, the officer can declare and keep the item. But if it's more than a value of 500, then the officer will have to declare and surrender to the head of department. And it is up to the head of department to then make the decision, either to allow the officer to keep it, or maybe just have the accept the item, the gift, and it is for the general purpose of the office, or at a very serious case, the gift will be returned to the sender with a nice thank you note. Right? That this is our policy, but we cannot accept. But thank you very much. We value your friendship. We value your commitment to fight corruption, and give a nice, motivating message and tell them, please, if you're trying to bribe, don't try again. I got to say but you do it subtly.
Yeah. But
so,
good example.
So these are
good
some
example.
of the, So these are some of the things that companies should look into. Facilitation payments, for example, you must be aware. In America, facilitation payment is allowed. It is legal, but not in any other country. In Malaysia, for example, facilitation payments are a big no-no. And of course, now there's a big sort of review and things like that on political donation. So we hope that sometime soon we will see the light of an act which addresses the issue of political funding. So I think for
in due course.
In due course, we pray. We pray. So and other things that are quite normal are conflict of interest policies and so on and so forth. So these are some of examples in which area financial controls, managing your processes, procedure. And I must say that while you look at processes, right? Normally in any organization, when issues turn up, the first thing that anybody looks at is, oh, what is our policy? What's our procedure? But very rarely, or I would say it is a weak approach when it comes to people. The people aspect is highly important. You may have the best policies, you may have the best procedures, but the policy and procedures are only as good as the people running it.
Hang on, Jayantha. Since you're there, right? Because you're talking about policies and due diligence. Sorry, I don't mean to disturb your chain of thoughts.
No
but because
problem.
there happened to be a question here which is on point to what you are talking about from one of the participants, Ray Patrick. He inquired that what if for due diligence, if the company, for example, have about 1,000 people, is it expected within the definition of adequate procedure? Is it expected to do a due diligence on all 1,000 people? What is your general observation on that, Jayantha?
Let's put it this way. In an organization, everything. If you take to COVID, if you relate it to COVID, would you like to leave behind someone untested?
So it is better to test as many people as possible, right, to avoid the viral spread.
Yes, prevention is better than cure.
Yeah,
right. So
I like the answer.
Yeah, it is better to actually cover everybody else, right? In material of the size. Yeah, I know it's going to be a tedious process, but the thing is, for example, there are organizations that conduct what you call integrity test, integrity assessment of the individual. So they would run and make it something compulsory. They would have things like psychometric analysis of their employees, which is basically looking at the level of integrity of a person, right? And they would have such assessment done on a compulsory and annual basis. Now there's I would share one practice is if you look at Panasonic, they have this on an annual basis and they run it. Of course, when I ask them, how was it initially, say, yeah, initially you don't get that kind of good response, but the thing is you got to put a carrot to it. That means you make it compulsory and you say that failure to complete this assessment will impact on your on your what do you call annual employee assessment, which leads to bonuses and promotions and so on and so forth. So there is an impact, or there is an implication for failure to undergo this particular assessment. And it's something, you can make it very simple, but yet something important. For the case of Panasonic, they have a questionnaire that they run, and they give them a period of maybe I think a couple of months, within a framework of a few months, that you go ahead and do it. You may complete it at one go, or you may want to do it in installments. That is perfectly fine, but by such and such a date, the whole exercise should be completed, and you submit it online. It's an online submission, so it is monitored by a system, and HR gets it, and then they do the analysis, and they would see what happens. Other things under this particular controlling measure is basically looking at hot jobs. Now, does your organization and does your operations have any hot jobs? If you have hot jobs, for example, places where a particular process, a particular job function, which possibly leads to corruption, or there's a high risk of corruption, whether by default, by default. For example, if you take government departments, by default, the MOF is a high risk department, immaterial of whether there is corruption or not, right? The risk rating is by default very high because of the fact that they deal with monetary issues, and corruption is all about money, right? Show me the money, show me the money. That's the tagline.
Okay.
And secondly, you get things like ministries or things like deal with high valued tenders and all that, like the defense ministry. Immaterial of whether it's a clean ministry or not, it always poses a high risk for corruption to happen, because the tenders in such industries and such a scope of work is always at a high value. It is not low value, right? So likewise, in your organization, then organizations will need to identify what are there any hot jobs. For example, if you take in any company, the most no-brainer hot job is the tender. Those who deal with procurement. So those who deal with procurement, because that's the guy who will decide who gets the contract for, whether it's supplying of stationery or office equipments, things like that, basic things, right? Even if you think purchasing paper is something, it sounds very minimal or very small, but when you look at the contract, right? Because today we use a lot of paper, and when you look at the contract that deals with it, it is, the value can be substantial, and as such, your procurement people, become people of high risk. So when they are at high risk, that's when that particular job is considered as a hot job. So what should happen is, while we like to have specialists, but we do not want people who are comfortable in the organization. Because in corruption, in the theory of corruption and the analysis of corruption, there's something called, in Malay, it is better framed. It says, why does corruption happen? Because there is ruang dan peluang, meaning there is the space and opportunity to do it. If there's no space, no opportunity, people would not do it. So people who are involved in corruption, they would always look for the space and opportunity to do it. So and it would be, for example, like in a tender, okay, because you are people in control. You have the decision making power, or decision making. You are authorized to make those decisions. So as such, become powerful. And people, like they say, power corrupts. What do you call?
Absolutely.
Absolutely.
Not like that.
So power is something very, very strong, but it can also be abused, right? So we must be very, very careful. So people who sit in hot jobs should be rotated, so that you do not make somebody comfortable, because a comfortable person may or may not. I'm not saying all comfortable people might do it, no, but there's a possibility, because our mind can play tricks. I always tell people there are two kinds of mind. You have a monkey mind and a devil's mind. A monkey mind is easy to control, but a devil's mind will end up going against the law. The devil's mind is the one that always looks for opportunity to break the law, to bend the law, and to find ways and means for their, to do things for their own benefit, especially when it comes to corruption. So we must be very careful. We must analyze. So human resource should analyze the various job functions in an organization to determine whether it's a hot job. If it's a hot job, then can we rotate the people on this hot job, so that they don't become comfortable and start looking for opportunities, and create spaces for corruption to take to set in. Okay, so once we are done with once it's rolled out, okay, the next step is, while you roll out, then you should have a periodical monitoring, a review of all these processes, this workflow, the initiatives, and so on and so forth, right? For example, you should review what today is of high risk, tomorrow, over a period of time, may be low risk. So you may reduce, you may rework your finances and reallocate your budget so that you do not waste, but you realign your budget so that it goes to another area which is of high risk. At the same time, what is of no risk today may be due to future government policies or industry requirements or business requirements now could, in a later period, could turn into a possible medium risk or high risk in terms of corruption. So we should have periodical review, monitoring, and while we are enforcing all our mitigation plans, right? So conducting internal audits, reviews for continuous evaluation, improvements, and so on and so forth, right? So these are, so basically until now, it's a no-brainer. It's not rocket science. It's pretty much how we run our family, run our home, run our office, or even manage our own selves. This is what we normally do, right? And finally, of course, it is training and communication. So in all of this, there must be regular training, regular communication of all these policies, all these initiatives, so that the entire organization is well aware. I must tell some of you all, just take a trip to Bank Muamalat. If you take a trip to Bank Muamalat, you would see on the lift, likewise AXA Insurance. Just go to AXA Insurance, on the lift, door lifts, and many other places they would find. Another example I can tell you is you go to the immigration department, because today the immigration department is, was the first government department to be given the ISO 37001 certification.
The certified ISO 37001. Yes.
Yeah, which is the anti-bribery management system. Now they are internationally certified, and if you go to immigration departments all over Malaysia, you would find, banners and posters and all kinds of ANP materials shouting at you and telling you, don't bribe, no bribery, no corruption, right? And what are the implications? So communication is very, very important, very highly relevant, and also training. Who are the people in your organization that could champion all this? So train the people, conduct seminars, training, just like what we are doing now. So it's not, I hope this is not just a one-off thing and you forget about it. So regular training is something very important, just like exercise. You got to regularly exercise in order to maintain your health. So in order to maintain the health of an organization, regular communication, regular training, regular dissemination of this information, and the various policies, procedure must be there, so that tomorrow it becomes part of your DNA as an employee. You become part of the whole system. You are a living policy. You are someone that sort of breathes, and like they used to say, the World Cup tagline, makan bola, minum bola, tidur bola. Yeah, so you must makan anti rasuah, tidur anti rasuah, and then
hidup anti rasuah.
Hidup anti rasuah. So this is the kind of work spirit, work culture, business culture, organization culture that 17A actually is looking at on a bigger scale, on a bigger picture.
Okay.
So this part of communication and all that. So that's basically trust.
Excellent.
So nothing rocket, it's not rocket science.
Yeah, thank you, Jay. Let me summarize what Thilaq and you have mentioned. Sorry, I have to correct Thilaq. In fact, the ministerial's announcement is 2018, not 2019. I'm sorry, Thilaq, I have to correct you there. But thank you. With regards to the trust concept, the principles of trust announced by the government in 2018 as a guideline, I have a few questions, but let me summarize first. So basically for the listeners, long story short, is basically addressing your mind to it under commitment, top level commitment, and then putting into place a risk assessment. You need to assess, find out what's happening in your company, basically know your company, and then start taking control measures to make sure that it doesn't happen, and then have a review all the time. So not just start today and implement today and then forget about it. We must have review, must always check. Like what Jay said, you have a family, you put a rule at home, you tell your children don't do. Every now and then you have to revisit that rule to make sure it doesn't happen. And then of course, you need to train the thing. So you need to make sure that if you are, so let's implement into the company. If you are a partner, an LLP partner, you need to accept that you're committed to anti-bribery. Then you assess in your company now what's happening, who, what, why, when, where. Once you do that, and as Jay said, if there's 1,000 workers, you may have to do a due diligence on all 1,000. And then after that, you start putting in measures, undertake control measures, what you can and cannot do. So in my experience, find very funny, Jay, because I've been doing sports for quite a while. And in sports, we have an integrity department in almost every major sports department. In fact, I advise on integrity many, many times. So I found it quite hilarious that a lot of people were saying, you know, Richard, what, like you do sports law. Now I find that I bring sports law into 17A because I actually know how integrity works. In fact, I just recommended to a client to appoint an integrity officer. The client was quite surprised. What is that, Richard? Integrity officer. So that's the one area. And then, of course, systematic review and then training. Have talks like this, have talks, call the MACC to come and give a talk and all that. So that is a summary. But moving forward,
I would like to highlight to our audience, you can call MACC at any time, and we are primarily FOC, you know. It's public service. So don't feel shy. Just make use of the, utilize your what you call taxpayers thing, and you have all the right, government agencies, government bodies, MACC, we are here for the public. So you can call it anytime.
Yeah. Thank you. So, but because there's some interesting questions already on board, and we are kind of going into 11:20 already, I thought we'd try and address some of the questions. Sure. Now, immediately, so we do two in one. So, for example, we have answered Ray Patrick's question about due diligence of 1,000 staff. Then Vince Chong asked, should we also do small businesses like the motorcycle repair shop? Should we do this kind of stuff, actual adequate procedure? I think the answer is yes. So long as a company, you fall within the definition in 17A1, the answer is yes, you have to comply. Then there's this perennial question, which I want you to try and address. People have asked this risk assessment, anti-corruption practices, ABMS, ISO 37001. What are your comments? Is the company obliged to enter into a risk management system? And if they do, and I know the answer is yes, then if they do that, anti-corruption system, must they take 37001 as one of it? So we had this discussion 2 weeks ago. Dr. Loy very eloquently explained 37001. It was very clear what is it about. Very good system. And people like him, they are able to advise on this kind of stuff. But for MACC's point of view, what are the kind of anti-bribery system that we can put in for companies? All yours, Jayantha and Thilaq.
Basically it's etiquette measures. Now, there is no one size that fits all. There's no one product which is compulsory. It's basically a buffet. So the ISO certification is a buffet. It's one of the buffet items, and but I must say, like they say, the more the merrier, right? The more you have in place, the better your defense. Now you may want to go for ISO 37001, and all of these, in all of these measures, you should also assess your financial strength. It's of course there's always a budget to it. Nothing comes free in life, right? So you need to invest. So I wouldn't say you need to spend. I wouldn't classify it as an expenditure, but what I would like to term it as, let it be an investment, an integrity investment that would bring. You see, in all of this integrity investment, whether it's ABMS, whether it's products of MACC, for example, we have a corruption risk management program, CRM, we have a CIP, which is what we call corporate integrity. what we call corporate integrity plan, CIP. We also have a very simple initiative called Corruption-Free Pledge, or it goes by the acronym of IBR, Ikrar Bebas Rasuah. And many other things. The CEIO program, which is done by our academy, conducted by the academy, looks into training individuals to be integrity officers in organizations. So that is something that we have for the public sector, for people from the private sector, and also international participants. If you go to our academy page in our website, the information is there. And in fact, later I can just share the information with you, Richard. You can share it with the audience. And this is something that these are some of the things that we do, right? ISO certification, of course, there's a plus to it, because number one, it is quite an extensive program. It is spearheaded by SIRIM, and it is of international recognition, and also various other initiatives. For example, if you look at IIM, they have a psychometric analysis product. So for which so there are many agencies that have certain products and services which you can choose and see what fits in your organization, or what would be strong enough for you to do it. I even know of organizations which I've asked, they've told me that, oh, okay, we are already, developing our framework. So first thing I ask is, so how are you doing it? Are you engaging any consultants or not? He said, no, our management have decided, let us do DIY, do it yourself. Today with the power of internet and power of information available, I think most of the time all you need is a bit of time to sit down and do some research and to see. There are many templates out there. There are many stories out there, and it's just about sitting down and picking out relevant information, plotting it, and mapping it out properly on a particular framework, on a particular product template, and then see what fits best
What
and
fits
what
your best? Yeah.
feel would be very, very strong enough to protect your organization against any possible implication of 17A.
Yeah.
So it's a buffet out there. Nothing is compulsory, right? So you can pick and choose based on your financial resources. But like I said, don't just say, okay lah, I just pick one enough lah. No, this is not three musketeers, all for one, one for all. It's not that. So, but what I would say is the more the merrier.
Yeah. Thank you. So, I mean, to be frank, Jayantha, in my review so far, I find, of course, ISO 37001, and also because ISO is from Switzerland, the British, they have their own anti-bribery system also there, their own standards there. These are all standards which I think major corporate companies can refer to and maybe apply to the companies. But in like example given by Mr. Vince Chong, what about the motorcycle repair shop, small company, right? So they may want to apply a more simplified and based on a budget anti-corruption risk management. Yeah. So that's a good answer. At least it gives us a direction. And then correct me if I'm sorry, I have to repeat this, Jayantha, because I think I want people to really understand. At the end of the day, I think we must let everyone know that even if you put all this into measures, it is still up to the court to decide whether it's adequate procedure. Correct? Yeah. Yeah. So of course, the more you put, the more inclined the court should accept your defense as adequate procedure.
You go to court, they ask you how many initiatives you have and explain. So if you explain only one initiative, your time is only maybe 10 minutes. But you got 10 initiatives, the judge has to sit down and listen to all 10, and probably they go, okay.
I wouldn't be surprised.
You buy time, and I think as lawyers, what you all want is you want to have more time to argue, correct?
Well, sometimes, yeah. But on that point, Jayantha, before I go back to you and Thilaq, one of the Q&A here, and even in the chat room, because we have two chats going on here, inquired about any case laws. Is there any foreign, for example, Leonard Tan asked, is there any foreign real life example we can refer to? So at this point, if you don't mind, let me have a word, Jayantha. I refer to the case of Crown against Skansen Interiors. Skansen, some people call it Skansen Interiors. It is a British case. In the Skansen Interiors, Leonard, very interesting fact. Skansen was in fact a defendant. They are a small refurbishment company based in London. They do renovation and repair work. Their managing director was actually alleged to have made 2 payments of £10,000. Then, following internal investigation, Skansen actually acknowledged that they were wrong. They reported the wrongdoing to the National Crime Agency to arrest their former managing director. But to their surprise, they themselves were charged, because in England, failure to comply and adhere to adequate procedure itself may be an offence. And even though they did their own internal check, they investigated and found the wrong, but the court held that they were indeed inadequate, and they were charged and convicted for inadequacy of protection. Why? Because even though they managed to investigate and discover that the managing director was actually practicing corrupt practices, but they failed to prevent it. They failed to do our version of TRUST. So that is an example of a British case, which I think will be used quite heavily in Malaysia when the time comes. Just an example, Jayantha. Do you have any cases you want to add to that, Jayantha? Or Thilaq, any of you want to try and...
You see, if you take, you take the, the Skansen, there's also, Rolls-Royce in UK, and so on and so forth. At the end of the day, see, I'll give you a very simple example, right? What happened to Siemens is a classic example, right? They were implicated, and they had to. But the thing is, no company, no major brand today would want to go through prosecution. Nobody.
They want to avoid it, yeah.
They want to avoid prosecution as much as possible, right? So when DPA was offered, they took it, but that does not mean that they have not committed the offense, right? In DPA, basically, yeah, you have committed an offense, but okay, you're excused from prosecution. Now, under the DPA agreement, you have to fulfill the criteria or the requirements decided by the court, right? So if I take the thing about Siemens, is they have to go through a major revamp. They spend a lot of money, over and above having a total management change, employee training, and so many other things. It costs them a lot of money internally, management costs. Over and above, they still had to pay a fine to the courts amounting to 2.25 billion euros. Right?
Interesting.
So you may not go. So DPA is basically simple. You don't go through prosecution, but you still pay the fine. Something, there is a penalty. There is a penalty. Another case is that because everybody hears the same things. So I like to go slightly different. There's a case of where a top executive of Morgan Stanley was implicated for bribing officials and public officials in China. And when that case came about, he's a top official in Morgan Stanley. And when they implicated, so what they did was went after the individual and also the organization. Now, Morgan Stanley then, for their defense, they put up their case by saying that they have anti-corruption policies, anti-corruption measures, anti-corruption framework in place. And they proved to the courts that they have all these in place. Right? They even proved to the courts that they provided copies of certificates of attendance of this particular ED who had attended various training programs, briefings, seminars, and so on and so forth related to corporate governance, related to integrity, related to anti-corruption and all that. So together with register of attendance and so on and so forth. So when they proved all this to the courts, and the court was convinced that as an organization, yes, they have proved themselves, they've defended well, and as such, it is the courts deem that the organization does not condone, right? Upon that convincing, and it was only then that the particular ED was then charged individually under the what you call the individual offenses, right? So these are some, and in all of this, the most important thing here is I would like to emphasize is the element of documentation. The documentation exercise must be thorough and must not be taken lightly. Everything has to be minuted. Tomorrow, if you as a senior manager, as a board member, as a CEO, MD, if you do not agree with a particular decision by the board or by the senior management or whatever, make sure it is minuted. Don't let it go by way of hearsay. Don't let it go whereby later you have to say, no, I mentioned. And when you ask the rest of them, no, I don't think so. I heard it that way. So we do not want such, vague responses. So what you call the most safest is documentation. If it's in a meeting, if it's a decision, ensure that it is minuted. Because, like we mentioned, people who are non-liable, right? People who are persons who are non-liable under 17A are number one, if you can prove that the act was done without your consent. So if you can prove that the act of corruption was committed without your consent, then you become non-liable. Or in a situation where you can prove to the courts that the act of corruption was done, in addition, or basically, if you can prove to the courts that you as part of the controller or person being implicated, now you prove that you have taken all the necessary, you have conducted all due diligences,
and yet it happened.
Prevent, and yet it happened.
So at least you can have a defense. Yeah,
that becomes your defense. So maybe that minute of the meeting can be your saving grace.
Yeah. So very good point, ladies and gentlemen. Just to remind you again, whatever Mr. Thilaq and Jayantha is saying are all guidelines. Please don't go to court one day and say Jayantha say. It's not that. But these are all guidelines. Very, very, very good guidelines. In fact. So in fact, I want to ask some of the questions, Thilaq and Jayantha. Like Dr. Loy asked here. He asked ministerial guidelines on adequate procedure, particularly the second principle on risk management. Dr. Loy asked, it is recommended that the comprehensive risk assessment is done every 3 years. So it goes back to what you said just now. You show all you can, right? Show all you can. And he says that you must do a comprehensive risk management assessment every 3 years with intermittent assessment conducted when necessary. Could you elaborate that? How do you define risk assessment here under TRUST, the R part? Maybe Jayantha or Thilaq wants to give a try. How do you elaborate this intermittent assessments?
For those of you who are patients in a hospital, minimum, at the very minimum, once a year checkup, correct? Yeah.
Okay.
Your checkup, if you're at a very low risk of health, right? If you do not pose severe symptoms and whatnot, the doctors will tell you to visit them once a year, correct? That is at the more bare minimum, once a year. If you show symptoms, if you show recurring problems and so on and so forth, they might tell you come every quarterly, or they might tell you to come every 6 months, or they might tell you to come every 2 months, or even monthly. That depends on the level of severity of your symptoms or your health condition. Now, it is similar to this. So the organization has that kind of risk. So you need to assess the risk of your corruption. Now, how often you want to do it, it is up to you. But you should conduct such assessments regularly. Yeah, it is recommended as 3. It is not said that it is compulsory to do it every 3 years. It is only recommended as a theoretical explanation.
Yeah.
But you may want to do it every year. You may want to do it maybe instead of 3 years, you may want to do it every 2 years or every 5 years. That's okay. It depends on how you want to do it, right? But the most important thing here is to revisit your policies, procedures, regulations, and so on and so forth, and to rate and to re-rate, to reassess. Is today's low risk tomorrow's high risk? Is tomorrow's high risk today's low risk? Or is it going to medium risk? Or maybe something that is no risk at all. You never imagine it would be a risk to corruption, but in a future time period, suddenly it surfaces as a possible risk.
Yeah.
So that revisiting is similar to how we go through our own self health checks and hospital appointments. Is the same analogy.
Yeah. Thank you, Jay. What an easy way to understand. Thank you. So basically, I remembered earlier part of the discussion. You mentioned about organizations like, for example, the Ministry of Finance, clearly highly exposed. So obviously, in that kind of organizations, or if your company is involved in that kind of business, then it is highly recommended that you do your risk assessment more frequently, isn't it? Yeah. But I love your analogy, very easy to understand. Now, before I go back to the Q&A, especially there's a few interesting questions from Dr. Loy. One of the participants, Miss Joanne Long, inquired whether we could receive a copy of the slides. Is it possible, Jenna, or is this, to be fair, is it a private slide by MACC?
Private.
Sorry, the line broke down. Sorry, what do you say?
It is private and confidential and only for Malaysian citizens.
So I suppose later on we will ask the Malaysian citizen in BAC to ask it from you lah.
No. This is public information. No problem.
Okay, thank you. So Miss Joanne, and to all of you here who have registered, only those registered here in Zoom, those registered here in Zoom, we will get a copy from Mr. Thilaq and Mr. Jayantha, and then a copy will be emailed to you. I think Miss Julie from BAC will handle that. This is under BAC, not under RWC, but we will help BAC to do this. Okay, back to the Q&A. So some interesting Q&A. I'm going to try to summarize it because we are really taking up too much time already. And I think
Richard, just one caution there. With the slides, while we are willing to share this, openly with the public, our earnest plea and earnest request is that please do not take advantage of it. It is for your personal consumption, and we hope that you don't take it and you buat harta and then you bikin harta. Because there are many people who take it and then go and show it as their own slide.
Yeah, cut and paste.
And they make tons of money consulting. You see, you all must understand, dear listeners, viewers, you all must, audience, please understand. They are proper consultants, right? Then you have the consultants. So you must be able to distinguish who is who. Because many people will come and give you a nice big picture, then they'll throw you a big fat, a quotation, and put in fear that, oh, you better have this, oh, otherwise like this, oh, that. Please, in doubt, give us a call. Give us a call. You want to run a check, give us a call. We will advise you as much as possible, right? But there are many things that, like I said, there are organizations who do it DIY. All it needs is a bit of hard work and the eagerness to do it. So yeah, but of course, you should assess. You should assess the people that come to you. And
I would recommend, Jayantha, I totally agree with you, because sometimes even my slides have been used up by other people. Perhaps you can try one of the ways to limit it is to make it into PDF and limit it. You can even put a password to it, for example. Anyway, never mind. But thank you so much for your willingness to share. Because I'm worried that the webinar, we need to use Zoom. BAC may need to use the Zoom for other events later. But Miss Julie indicated that we still have time. Miss Julie from BAC indicated we still have time. But I don't want to take it too much time because I think BAC may need the Zoom for other classes. So to summarize, Dr. Loy asked 3 very good questions. The first question is, when do you think MACC will be expected to file its first case? I think no disrespect to Dr. Loy, it will be difficult to answer that, because if I'm the prosecutor, my answer will be, how would I know? Somebody, only when somebody do wrong, I prosecute lah. But I'll let you answer. Number 2, Dr. Loy asked a very good question. He said that, how far back will MACC probe? So basically, this is a retrospective question, whether we'll go back before 1st of June 2020 for all offences done before 1st of June 2020. Can someone get arrested now? And the third one is that he talks about the DPA, Deferred Prosecution Agreement, whether we have, why we don't have such a thing in Malaysia. So let's take the first one first. Jayantha, Thilaq, when do you think will be the first case?
Okay, I think we go on a legal, legally answering this. Okay, our act was implemented on 1st of June. Yes, Monday.
Yeah,
okay,
it's
Monday.
A few days ago, yeah.
Today's Friday. Okay. So on a legal term, any offence committed after the act is implemented, meaning to say any offences committed from Monday, from the 1st, can be charged under the section 17A. So if you have bribed somebody on Sunday or Saturday, your employee is going to be charged for the corrupt act, but your company won't be charged because it was committed before the date the act was implemented. So I think I answer both the questions lah.
One shot. Yes.
Mr. Lo's first question, second question, how far can MACC probe? I can only probe until this Monday. Cannot go further than that because that is what the law says lah. Anybody who is charged for an offence committed after the law is implemented. For an example, maybe like now we have an MACC Act which was implemented in 2009. It's called Akta Suruhanjaya Pencegahan Rasuah Malaysia. Before that, we had Akta Pencegahan Rasuah. So any offence committed before the date in 2009, maybe meaning to say there was a corrupt practice in 2007, and now we are going to go to investigate that case, we have to use the provisions from that act.
I see.
So
thank you.
Meaning to say anything committed, okay, if for what he asked, when is the earliest we can charge? Something happened on Monday and maybe somebody came and reported to us today or yesterday. We have to take 1 or 2 weeks, maybe 1 month to investigate, then maybe we can see now. But the offence must be committed after the date of the implementation of the act. So meaning to say after 1st of June.
It looks like a very good question. So there's no, for those who are lawyers here, some of the viewers here are lawyers, even especially on Facebook, with the number of lawyers I can see logged on to watch. In your view, it should not be retrospective. It should not be retrospective. Yeah. I use the word it should not because you never know. What today is not retrospective. Suddenly, the prosecutor may take otherwise.
Yes.
So yes, okay, thank you. But I think to be fair, I think that makes sense because
that is fair, because if you go and probe something which happened 10 years ago, that is not fair to everybody, because the meaning to say at that time and space that the law was not there, so I didn't follow it.
Yeah,
that is answer by a legal. It's not morally right or anything, but as a legal spec, that is the answer. So
yeah,
as legal, you have to follow the law and say act was implemented at this day. So for the time now, everybody is considered adequately informed about it. So anything happening after that is considered wrong.
I tend to agree with you. I tend to agree. It makes a lot of sense. Yeah. Okay. So the next question from Dr. Loy, before we go to
about
he
the
asked
DPA.
one more. He asked about the DPA. Do you have any comment on that?
Okay. For the time being, we have not planned to. There is nothing considering to implement a DPA or insert it. There was discussions earlier, but I am pretty sure, I think Malaysian government are not planning to implement or insert it in DPA. Maybe there will be an amendment in future. If there's a consideration, we have a lot of cases to deal with, then maybe DPA may be an option. For the time being, we don't have any cases under 17A yet. So let's see. I think in future, because yes, DPA is a better way lah. Because if you go to a court and you take up time, you take up everybody's time and expenses also for the government, DPA is a good option. But for the time, because we are not sure lah, whether it's going to be inserted or not, maybe in the future.
Hang on, Thilaq. For everyone's understanding, of course, Dr. Loy is very well versed in this area, but not everybody here may know what is DPA. Can I trouble you, Thilaq? I mean, I know what it is, but yeah. Very quick explanation. Yeah.
It's an out of court settlement lah. DPA is considered something, meaning to say, okay, if in section 17A, if you follow the law, the company will be charged, and also the director or the board will be charged because they did not provide adequate measures in making their staff not to commit any corrupt practice, right? So in this condition, DPA is considered how? If the employee is charged for doing a corrupt practice, the company is going to be charged, and then DPA, meaning to say there will be a dealing where the company will agree to some guidelines, not only just paying a fine. Maybe they also will be agreeing to some other guidelines of good conduct, and also some countries will have implemented, okay, for the time being, for the next 5 years, you cannot apply for any government tenders and all that lah. That is what inclusive of what have they decided on lah. But mainly to prevent them from going to court, to prevent them from getting tarnished their name lah. So most probably any company would agree to it lah.
Interesting.
For the time being, we don't have that option yet. So I'm sorry to say, if your employee does something wrong and then you get charged, you have to go to court lah.
Yeah, for now.
And then one more thing lah. Okay, like what if we have talked about for the past 1 hour etiquette measures lah. If you ask me personally, the most best etiquette measure is that your employees don't make mistakes. The moment they do something wrong, your all your etiquette measures gone down the drain lah, because then you have to go to investigation, you have to prove that you did this. So if you can keep your employees from making mistakes, that is the most etiquette measure.
Yeah. In fact, I think Thilaq, companies, unless of course you are a tiny company, a micro company, but if you are an SME, is the larger SMEs, and of course the major corporates, blah blah blah, they should have a compliance system or a compliant officer or integrity officer involved. I think they must look at that from now onwards. Yeah. And of course, like I said, for me, sports law, we already have that in all the major sports association. So, okay, we'll come to the last question because I really want to wrap it up. Vince Chong inquired. Vince Chong is, of course, a fellow member of the bar. He asked, in the guideline, it's recommended that companies conduct third-party due diligence before entering into the contract. How far do you think we need to go? Do you need to determine if they have an anti-bribery policy? And if the third party is a local kedai runcit and they don't have policy, does that mean we cannot do business with them? Some interesting question. Maybe Jayantha, you want to give it a try?
Third party due diligence or any form of due diligence, you see, basically it's up to you. There's no, today there's no industry sanction or industry regulation or things like that. But that does not prevent from anything to happen.
Yeah.
The Bursa has already put in place certain things in terms of anti-corruption reporting and things like that, which is compulsory. So that is one element. Now, what one wants to do is basically up to them. It's basically at what level of seriousness do you want to take this anti-corruption framework of protecting what you call the commercial fraternity from corruption. So if you want to be stern, you want to be strict, that is perfectly up to you. For example, I think if I'm not mistaken, in Thailand there's some form of self-regulatory due diligence things, whereby if, for example, if you are within the band of people or band of organizations that have such measures or have a particular policy or certification or some form of qualification, you sort of you make yourself like an elite group, and subsequently you just conduct businesses among yourselves, right? And if anybody wants to participate into this group, the only option is they follow suit and obtain those qualifications or certifications or skills or whatever the requirements, right? So here, likewise, of course, it's up to you basically, what you want to do. We never, I mean, everything is new. One thing that, all these questions are coming up, and I think, these questions are still very, very elementary, very, very at a very infant stage. Many of us will not see any light of it in the nearest possible time. But I'm sure these questions, if we keep in the next 2 years, it will be important.
And you'll be answered eventually. You'll be answered.
Eventually, because if things are heading towards a very, very serious scenario, then maybe, we might have to do something like to the effect of MCO or CMCO or lockdown or things like that, where we put in this regulation, that regulation, only such people can go in, only this can happen, only that can happen. Maybe, for example, maybe the government might, I don't know, it could be maybe some suggestions could come in to say that, okay, for large tenders or something like that, what do you call, part of the requirements could be obtaining a particular certification or ensuring that you have whatever qualification, whatever, it could be anything. So it's basically up to the regulators, up to the government, up to the decision makers. Sometimes you do not want things to be very, very difficult. Like during the MCO, it was very difficult, very challenging for businesses and many people. Everybody was crying, right? CMCO came in and it was relaxed a bit. So from crying, it became tearing, right? After PM's announcement, there could be some more relaxation, and so from tearing it could be just weeping, and maybe it's a bit of laughter here and there.
Yeah.
So it's basically up to how the regulators, the government itself, and the policymakers, and so on and so forth, feel how would they want to regulate their industry or their environment. If you have strict measures, so be it. If you ask me honestly, my own personal opinion would be, if I'm making the decision, I wouldn't want DPA in the infant stage of after some.
Yeah.
As the situation and the scenario becomes controlled, people are more they are more properly behaved. The level of code of ethics, level of integrity in corporate Malaysia increases. Okay, then maybe we can introduce DPA as a form of something like an option for those who have been working hard, but they have to go through certain legalities due to the irresponsibility of some of their employees, right? But not at the, I hope it's not at the infant stage. I mean, if I'm a person who is making the decision, I would say not now, but maybe later. Let's look whether the entire business population is behaving well and really taking anti-corruption very, very, very seriously.
Yeah. Thank you, Jayantha. Thank you, Thilaq. Very good summary. If I can summarize our dialogue today, it is really a real honor, and I must say very insightful to actually have someone from MACC with us. It is not easy to try and get MACC to join us. I'm very thankful to Jayantha and Thilaq, who have considered your time to join us. And I know that you are always available. I thank you for that, Jayantha. And to summarize today's talk is that we now understand who are the people who may unfortunately fall within this category: directors, company CEO, partners, etc., etc. We've given the list, and then we also understand what is 17A1. In short, when your subordinate do something wrong, then you as the boss may be liable, but you have a defense, and we spent a lot of time explaining the defense under 17A4. You heard some discussions on the ambit of the 17A4. There was an interesting question whether it goes retrospective. Mr. Thilaq has made it clear that in his view, it shouldn't be retrospective, and I tend to agree with that. And we also saw that how Jayantha and Thilaq explained how the whole 17A1, 2, 3, 4, 5, 6 works. And also we heard potential future evolution where we may add in the out-of-court settlement as one of the ways to come in one day. You never know. So in short, ladies and gentlemen, the slides may be will be shared with you later in due course. Please give us some time. I would say this: I think today's discussion is a very insightful, easy to understand, designed for laymen, and hopefully the message will go out of what the companies must do from now on, right? So before I wrap it up, can I first invite Jayantha and Thilaq, any short summary before we call it a day? Jayantha, Thilaq?
Short summary is, just ensure you do not become the first case for us. Just put in the etiquette measures. Don't worry about the penalties. Don't worry whether what the industry is doing, this and that. Just ensure that you start the ball rolling and make sure you have adequate measures to prevent corruption. That is the spirit of the law. It is not to penalize you, but it is to encourage you to have what you call anti-corruption measures in place. On that note, I think on the slide, what I put is what you call QR code for evaluation. So we would greatly appreciate appreciate if the audience, you all could just fill up this evaluation and just send it over.
Provide feedback. Yeah.
Please, what you call, take a shot of this of the QR code. It will lead you to the page. So please do that as part of your responsibility as an audience.
Yeah. All right. Thanks, Jaya. Thank you, Thilaq. So, Thilaq, anything you want to say, Thilaq?
No, I think Tuan Jay has summarized everything.
Okay, thank you. Thank you very much. Thank you so much for your time. So, ladies and gentlemen, please scan the QR. Yes, Jaya?
Yeah.
Sorry, Jay, I can't hear you. Sorry, can't hear you.
Thank you, to you for patching MACC with BAC. Julie, thanks for, coming on board. And I hope, you take advantage of MACC and we can, definitely be something of a value, especially for your law course, and maybe for y'all to dwell into, specifics on the MACC Act, which could benefit your law students in the long run.
Yeah, I wouldn't be surprised BAC contact you, Jayantha. So
no problem.
Yeah. So to bring this to a conclusion, a few things. Number one, at the peak of the webinar here, we had 32 people. Thank you so much for logging in. Many other people were watching us on Facebook, and the Facebook live broadcast was shared in many pages. So thank you everybody on Facebook for watching in. And those who are who missed this, you can always go back to Facebook. Look for Richard V. Chambers' Facebook page. You can watch it again because it's permanently going to be on Facebook, just like YouTube will be there. Eventually, this video will be downloaded and re-uploaded into YouTube. So you can also find this on YouTube by next week. In fact, by maybe even the next 2 days. Secondly,
while doing that, please be a responsible social media person by not sensitizing anything. for your personal pleasure or for your, because I know I must say this as not as accusing, but more of a reminder, because today I think we have many irresponsible social media people out there who take context out of proportion. So just be responsible in your thing, and we would appreciate it if you take it, as a personal information, and sharing. The sharing should be something which is for a greater good. That is more important.
Thank you, Jayantha. Thanks for the reminder. Indeed, I think we have to be responsible and accountable, especially when we are sharing on social media. So this video will eventually be on YouTube. And then thirdly, can I invite everybody here to give a cyber round of applause to Jaya and Thilaq? Yeah, you put your ears on the screen, you can hear them, loud cheer, yay, But thank you very much. I thought you presented the talk really well and easy to understand. Thank you, thank you, thank you. Yes, and of course, I want to thank, on behalf of the speakers and myself as moderator, I want to thank Brickfields College for sharing their Zoom with us, the IT team. I want to thank Miss Julie for the support. Thank you to all of you who's watching in today. What was supposed to be a 1 hour webinar has turned out to be 2 hours, but that's because the topic is very, very important. So it makes sense. Yeah. And so with that in mind, ladies and gentlemen, I'll end it here. But with this message that 17A is not just about one person, it's about all persons. And in the especially I'm talking about company, and in the company, it is now is the time for every single person in a company to be accountable, responsible, and to assess yourself at all times to make sure that you don't get charged for this. Don't get involved.
Echoing Richard, though it is late, but as they say, better late than never.
Than never, yeah. So it is our duty not to get involved in corruption. In fact, to me, the best way is that don't get involved. No corruption. That's the best way. No corruption. You don't even have to talk about, yeah, correct. So if there's no corruption, we don't even have to bother about 17A4 adequate procedure. Irrelevant. Yeah. So if your company is clean,
just keep inviting us. You find smiling faces, happy faces.
Okay. Yeah. So in fact, Jayantha, I do intend to invite you again for my other talks with other clients. Maybe there are many people who wouldn't mind listening to you. And RWC is more than willing. We are already hosting more than 25, 26 webinars. So, we would love to organize a few more webinars with MACC in the future. Maybe. Okay. With that in mind, thank you, everybody. Adios, amigos. Take care of yourself. And
please don't forget the online evaluation, as you see on the QR code.
So don't forget the evaluation, guys, to support our MACC. And then thank you, everybody. Thank you, MACC. And thank you, BAC. Adios, amigos. Take care. Bye-bye.
Cheers.